श्रीमती परनीत कौर जी।
Mr. Chairman, sir, thank you very much for giving me the time to speak. I stand to share a few thoughts on these amendments proposed by the government on the Juvenile Justice, Care and Protection of Children Act on behalf of my party. Let me begin by seeking to place the present amendments in a proper perspective. The Juvenile Justice, Care and Protection for Children Act, enacted in 2015, replaced the earlier Juvenile Justice, Care and Protection Act of 2000. This legislation was replaced the old Juvenile Justice Act of 1986. So we've had a series of legislations in the past 3 decades on this very important subject. And I do thank the Honorable Minister for bringing this up. And as she said, that we are all thankful that our children are being considered on a priority with the other important issues that are have been taken up in this session. The 2015 Legislation Act brought by the NDA government had the following aims and objectives. I quote, "An act to consolidate and amend the law relating to children alleged and found to be in conflict with law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, and by adopting a child-friendly approach in adjudication and disposal of matters at the behest of for the best interest of children and for their rehabilitation through processes provided and institutions and bodies established hereunder, and for matters connected therewith or incidental thereto," unquote. The present bill introduced by the Honorable Minister, Shrimati Smriti Irani ji, seeks to make certain amendments in the existing legislation of 2015. While we all support such a bill, let me say that we must all, as representatives of the people in this august House, consider carefully the proposals before taking any decision. What is at stake is how the society and criminal justice system deal with juveniles in conflict with law, and what institutional mechanisms are we proposing. Our guiding principle must be to ensure that these delinquents should be handled sensitively, reformed, and prevented from lapsing into the world of crime later as young adults. Chairman, sir, I would like to draw the attention of the House to some very key amendments and the import of the proposed changes. First and foremost, the proposed amendment puts the entire onus of the child's welfare on the district magistrates, ignoring the fact that the DMs have already been overburdened. They are overburdened authorities with the charge of the entire district on their shoulders. As members of Parliament, we all know the life of a district magistrate with his or her multifarious responsibilities. Under the proposed amendment, DMs will be the overarching authority for exercising all functions related to adoption, including the issuance of adoption orders without the requirement of court sanctions. Here the Minister has put forward her observations, which seem very relevant. They will also be responsible for functioning and regular monitoring of all child welfare agencies, such as the Child Welfare Committees and the Justice Juvenile Boards, the District Child Protection Units, and the Special Juvenile Protection Units, centralizing all powers and responsibilities with respect to a child's rehabilitation and reintegration into society in one authority, and this may lead to serious delays and can have wider repercussions on the child's welfare. So I urge you to consider this aspect carefully. While it needs saying, little needs saying that district administrations are the fulcrum of the district administration across India, we should be equally cognizant whether loading an already overburdened system will produce the desired results. This amendment has been introduced with the intent to further empower the DMs to act more decisively in the case of juvenile justice and child protection. However, what it really does in effect is gives them disproportionate powers and even more so responsibilities on the extremely sensitive issues on the DMs. However, if we collectively feel that these responsibilities need to be devolved upon the DMs, then the ministry should also consider providing them suitable assistance to ensure that this important issue of juvenile justice does not get sidetracked in the rigmarole of their day-to-day work. Secondly, the grievance redressal and conflict resolution powers have also been taken away from the judiciary and given to the executive. This is against the principle of separation of powers and takes away the role of the judges, who are specialized authorities when dealing with matters of law. We need to ask ourselves whether this proposed amendment will truly bring the desired changes. Thirdly, the categorization and distinction of serious crimes under proposed amendment from the category of heinous crimes under the current law was necessary. Under the prevailing law, juveniles aged 6 to 18 could be brought out of the protection of the juvenile justice system and tried as adults if they had committed a heinous crime. The latest amendment essentially limits the ambit and the circumstances under which this could take place, thereby protecting the rights of juveniles and only bringing those juveniles into the adult criminal system who have committed crimes and offenses where punishment for the offense exceeds 7 years. The new category of serious offenses is also in compliance with the Supreme Court judgment in Shilpa Mittal versus State of NCT of Delhi and another, 2020, wherein it was held by the two-judge bench that treating children as adults is an exception to the rule, and when two views are possible, then the view in favor of the children must be taken. This amendment is therefore a step in the right direction, since it brings the focus on rehabilitation of juvenile delinquents instead of retribution. The minister mentioned that the criteria for child welfare committees under Section 9 of the bill seeks to introduce a new criteria, which I think is very welcome, that you have specified what the guidelines should be for selecting the committee, and they should be held responsible. So I think that this is a very welcome step. Thank you very much. There was one thing in this, Honorable Minister, that I would like to say through the chairperson, that when you spoke in February 2021, you mentioned that there is no provision under law to check whether a person has been charged with girl-child abuse. I think we must address this critical loophole in the legal framework. The other thing was the budget cuts and the superficial changes that have been made. I know that in 2021 you had an allocation of about 1,500 crores, which was then downsized to 800 crores. And I think this year it's come up a little bit to 900 crores. And I think the committee reports, like you yourself said, have shown that there's been gross negligence in a lot of the homes, where even there are no special toilets, there's no place where they can change, there's no separation for the sexes, there are no beds, and a lot of other things. So to make sure that all this is properly dealt with, I think that the budget allocation should have been a little bit more. Chairman, sir, now that I have highlighted some of the key changes and their implications, I would like to place only one point for consideration to this House. Social legislations, such as the one we are sitting here for today to discuss and debate, these need to be considered very carefully. They are meant not only to provide a legal framework on any particular subject, but also they intend to mitigate certain social evils and improve social conditions with the aim of bringing about social reform. As they say, the taste of the pudding lies in the eating. Therefore, we must carefully consider both the intended and the unintended consequences of any legislative change we seek to enact, and also whether the existing legislations achieve its desired outcomes better than the proposed amendments. With these words, sir, I thank you for giving me time, and I hope that the Minister will take the few suggestions and implement them, and I do compliment her on bringing this very special Child Care Protection Amendment Act to this House, and I hope that we can serve and look after our children better. Thank you.